Okay, reading contracts, chapter 10, third parties, rights and responsibilities, on page 938. This is section 3, assignment of rights. B, within that section, obligor's duty to assignee, which includes some variations. If an assignment of an account has been made effective by Article 9 of the UCC, and the account debtor has received an appropriate notification of the assignment, a payment made on the account will not be credited to the account debtor. As to the terms account and account debtor in this statement, see earlier pages. The restatement makes a comparable statement generalized to obligors rather than account debtors. The restatement section reads in part, new paragraph, the right of an assignee is ... not subject to defenses or claims of the obligor which accrue after the obligor receives notification of the assignment, except as stated in the section or as provided by statute. Section 336(2). Observe that an obligor's defense, I have paid that, when faced with a claim by an assignee, constitutes a defense which accrued after notification unless the payment was made before the notification. The same section speaks also to the case of prior payment. The right of an assignee is subject to any defense or claim of the obligor which accrues before the obligor receives notification. The code rule about post-notification payments appears with particulars added in the UCC section 946. The rule about pre-notification payments appears in paragraph 2 of UCC section 9-404A, which, like the restatement, speaks in terms of the time when a defense accrues. The defense, I have paid that, is not one arising from the transaction that gave rise to the contract. A defense so arising is, for example, your claim is based on a contract that I may avoid owing to fraud by your assignor. The distinction is important because both the code and the restatement give way to that kind of defense. As for the code, a comparison between paragraphs 1 and 2 of section 9-404A demonstrates this. As for the restatement, see section 336-1. In the opinion that follows, the court set forth both paragraphs and applied paragraph 1. The defense concerned was based on a failure to pay, a failure on the part of the assignor to satisfy a debt that it owed to the account debtor. Introduction to DeLacy Investments vs. Thurman. The contestants in this appeal were DeLacy Investments as assignee and Remax as account debtor. Remax had won a default judgment below against Stephen Thurman, signer, owing to his failure to plead. He was not a party to the appeal. A note after the opinion speaks to his legal position. By reason of the assignment from Thurman to DeLacy, DeLacy had a security interest in the account in question. That interest was the nub of a security agreement between those parties. Hence, DeLacy was a secured party. The three terms in the italics are the subject of interrelated definitions in the Uniform Commercial Code. See section 1-201B35, the paragraph 72 and 73 of UCC section 9102A. The opinion reports that DeLacy had perfected his security interest by filing a UCC financing statement with the Minnesota Secretary of State. Something of the mechanics and effect of that precaution is described in the text below. It had little effect, if any, on the contest between DeLacy and Remax. The court quoted and referred to Minnesota statutes that track the Uniform Commercial Code, Minnesota Stat, section 336.9 through 404, which tracks UCC 9-404. As presented here, the opinion variably substitutes UCC for the prefix Minnesota Statute Section 336. The court stated the issue before and in it this way. Did the district court err by granting summary judgment to the respondent based on its interpretation of Article 9 of the Uniform Commercial Code as to assignment of an account receivable? DeLacy Investment Inc. versus Thurman and Remax Real Estate Guide Inc. This is heard by the Minnesota Court of Appeals in 2005. And the facts are as follows. Appellant DeLacy Investments Inc., doing business as Commission Express, CE, is in the business of factoring receivables from real estate agents. In this business, a real estate agent can assign or sell its future receivable or commission to CE in exchange for immediate funds. Respondent Remax Real Estate Guide Inc., Remax, is a real estate brokerage company. On November 11, 2001, defendant Stephen Thurman, a licensed real estate agent, entered into a master repurchase and security agreement, MRSA, with CE. The sub of the MRSA granted to CE a security interest under the UCC in all of Thurman's right, title, and interest in and to Thurman's current and future accounts receivable. CE perfected security interest by filing a UCC financing statement with the Minnesota Secretary of State. On February 25, 2003, Thurman entered into a standard independent contractor agreement with Remax. The agreement details the employment relationship between the two, whereby Thurman agreed to pay Remax certain overhead expenses. The agreement explains how Thurman will receive his commission from Remax and certain non-payment remedies. In permanent part, the agreement states, Thurman shall be deemed entitled only to 100% of the amount by which commissions generated by Thurman's efforts exceed past due financial obligations imposed by the terms of paragraph 4 and 5 of the agreement. That portion of commissions which does not exceed past due financial obligations shall be deemed to belong to Remax and shall be used by Remax first to offset arrearages owed by Thurman. Emphasis added. Thus, in terms of the legal relationships that exist here, CE is an assignee, having accepted Thurman's assignment of his commissions by the MRSA. Thurman, in turn, is an assigner, having assigned his right of commission to CE. Remax is an account debtor by virtue of its independent contractor agreement with Thurman, whereby Remax possesses the potential right to receipt of that which Thurman assigned to CE. In April of 2003, Remax executed an acknowledgement of the CE's security interest in Thurman's account receivable from the sale of a home on Javelin Avenue and directed that Thurman's commission from that sale be paid directly to CE. On April 22, 2003, CE and Thurman entered into an accounts receivable sale and assignment agreement, whereby CE agreed to purchase a $10,000 receivable related to Thurman's sale of a property on Keller Lake Drive in Burnsville, Keller Lake property. On June 7th, Remax terminated Thurman as a real estate agent for poor performance, failure to deposit earnest money payments in a timely manner, and customer complaints. Remax asserts that at the time of his termination, Thurman had accumulated $1,126.38 in overhead debts owed to Remax. As a result, Remax refused to pay the assigned receivable and applied the commission to Thurman's balance in accordance with the independent contractor agreement. Claim of right of set-off based on the overhead expenses that Thurman owed. In Remax's words, because the commissions earned by Remax as a result of Thurman's services did not exceed his past due financial obligation to Remax, Thurman was entitled to no compensation at the Keller Lake closing, and so nothing was paid to CE pursuant to the assignment. In June of 2003, CE sent Remax a demand for immediate payment of the Keller Lake account receivable and sent a notice of default to Thurman. Remax did not pay. CE then filed a complaint in district court. Remax answered and counterclaimed against Thurman. Both parties moved for Are we? Summary judgment. This district court denied CE's motion and granted RE/MAX's findings that CE's ability to receive a commission from RE/MAX is based on Thurman's assignment of contractual right to receive a commission from RE/MAX. Therefore, the district court determined that Thurman was not entitled to a commission at the time of the Keller Lake property closing. As a result, it was impossible for CE to obtain a greater right in the commission than Thurman had in the commission. This appeal follows. Analysis. On an appeal from summary judgment, we ask two questions. One, whether there are any genuine issues of material fact, and two, whether the district court erred in its application of the law. A. The district court's application of UCC 9404 in granting RE/MAX's motion for summary judgment, the district court determined that Thurman was not entitled to a commission at the time of the Keller Lake property closing. The court stated under UCC 9-404, an assignee's rights are subject to 1. All terms of the agreement between the account debtor and the assigner. The valid assignment generally operates to vest in the assignee and the same right, title, and interest that the assigner had in the thing assigned. In the present action, Thurman was not entitled to collect a commission while his fees were in arrears. There is no question that at the time of the closing on the Keller Lake property, Thurman was in arrears and his fees to RE/MAX in the amount of approximately $11,126.38. The court therefore finds that Thurman was not entitled to a commission at the time of the Keller Lake property closing and that it is impossible for CE to obtain a greater rate in the commission than Thurman had in the commission. So this was the trial court's decision. The Court of Appeals quoted from the rule again as follows, adding emphasis. Assignees' rights, subject to terms, claims, and defenses, exceptions, unless an account debtor has made an enforceable agreement not to assert defenses or claims. The subject to sections B through E, the rights of an assignee are subject to 1. All terms of the agreement between the account debtor and assigner, and any defense or claim in recoupment arising from the transaction that gave rise to the contract, and 2. Any other defense or claim of the account debtor against the assigner which accrues before the account debtor receives a notification of the assignment authenticated by the assigner or assignee. The official comment to the provision further explains its meaning. Subsection A provides that an assignee generally takes an assignment subject to defenses and claims of an account debtor. Under subsection A1, if the account debtor defenses on an assigned claim arise from the transaction that gave rise to the contract with the assigner, it makes no difference whether the defense or claim accrues before or after the account debtor is notified of the assignment. UCC 9-404, comment 2. See also Restatement Second of Contract Section 336, comment B, explaining that an assigner can assign only what he has and is subject to limitations imposed by the terms of that contract creating the right, and to defenses which would have been available against the account debtor had there been no assignment. The particular issue presented here is one of first impression in Minnesota. Under UCC 944A1, because of the rights of CE are subject to all terms of the agreement between RE/MAX and Thurman, namely the independent contractor agreement giving CE a right to all of Thurman's commissions which exceed past due financial obligations to RE/MAX, we conclude that CE cannot collect from RE/MAX because the commissions earned by RE/MAX as a result of Thurman's sales do not exceed his past due financial obligations to RE/MAX. As we recently explained, it is a black letter law that an assignee of a claim take no other or greater rates than the original assigner and cannot be in a better position than the assigner. And we're blaming that on a case, Farmers Insurance Company, or an illustration. The most basic principle of commercial law is reflected in the Latin phrase, nemo daci qui non habet, or no one may transfer more than he owns. Our decision is further supported by a number of courts across the country interpreting former 9-318 and revised 9-404 of the UCC. The Circuit Court has interpreted the same UCC provision to clearly limit the rights the assignee to those of the assignor and make its right to accounts receivable subject to the provisions of the account debtor's contract with the assignor. And this is from National City Bank Northwest versus Columbian Mutual Life Insurance Company case. In that case, the court concluded that there is no authority for the proposition that a perfected assignment to a third person takes precedence over the right of recoupment created between the original contracting parties in their contract. The court found support in a decision that an assignee was bound by an arbitration term in the agreement between the account debtor and the assigner. And that was in another case, Sistran Financial Services Corp. Versus Giant Cement Holding, Inc. From the opinion there, the court quoted as follows. If the assignee did not want to arbitrate disputes over collections from account debtors, it could have contracted with the assignor to prevent it from entering into any agreement that contained arbitration clauses. Because it did not do so, it is bound by the arbitration clause. Similarly here, if CE did not want to be bound by the independent contractor agreement between RE/MAX and Thurman, it could have contracted otherwise, but it did not, and CE is thereby bound by the independent contractor agreement between RE/MAX and Thurman. As an assignee, CE cannot assume greater rights than Thurman, the assigner. Subsection A2. But CE also argues that UCC 9-404A2 does not permit an account debtor to contract away the rights of an assignee after having received notice of a previously executed assignment. According to CE, subsection 2A2, limits which set off an account debtor may assert against a payment to the assignee after notice of the assignment. CE contends that RE/MAX had notice of the assignment on 3 separate occasions. One, statutory notice by CE's filing of the financing statement with the Secretary of State on November 14th of 2001 after Thurman's execution of the MRSA. 2, actual notice that CE was entitled to all of the Thurman receivables when a notice of default regarding the Javelin Avenue property was delivered by a certified mail on March 12th of 2003, and 3, actual notice from the assignment of the Keller Lake receivable on April 22nd, 2003. CE argues that Thurman signed the MRSA with CE, giving CE a right to his commission. Therefore, Thurman signed the independent contractor agreement with RE/MAX. The court quoted from UCC 1-201, 25, and 26. As enacted in Minnesota, it therefore appears that RE/MAX had notice of the assignment between Thurman and CE before its independent contractor agreement with Thurman. A perfected security interest is generally effective against creditors, except as otherwise provided in the Uniform Commercial Code. And that's from UCC 9-201A. Emphasis added. UCC 9-404A1 provides otherwise. And UCC 9-404A2 does not govern the dispute here. The plain language of UCC 9-404A1 makes clear that the rights of CE as the assignee are subject to all terms of the agreement between the account debtor and assigner. Here, the independent contractor agreement between RE/MAX and Thurman limited payment to Thurman to those commissions that exceeded his past due financial obligations to RE/MAX. Because CE can take no greater rights nor be in a better position than Thurman by recovering a commission when Thurman himself was not entitled to the commission, the district court did not err in granting summary judgment to RE/MAX. So the decision. We affirm the district court's grant of summary judgment in favor of the respondent. Working in